views and opinions expressed in this program are those of the participants and do not necessarily reflect the views of BronxNet or the program underwriters.
Welcome to today's verdict. I'm your host and trial attorney, David Lesch. We have a big show today, starting out with an interview from one of my co-hosts, Javier Gomez. Former Governor George Pataki will be on, talking to a little bit us about the 9/11 remembrance. We also have a lawsuit that was settled that has to do with the employees throughout the city who've been taken advantage of with respect to their working hours. A guest will be on the show to give you everything you need to know. And finally, we talk about the Board of Education and a disability lawsuit, vouchers that were not given out to the parents that they needed to have to make sure that their kids were given, the proper speech therapy and the different things that they need. It's a big show. Stay with us. Today's verdict starts right now. All right, as promised, we have the interview with Governor George Pataki. Javier Gomez is here. Take it away.
We welcome George E. Pataki, 53rd Governor of New York, in office from 1995 to 2006. Welcome, Governor.
Thank you, Javier. Nice being with you.
Governor, at the 20th anniversary of September 11th, what is on your mind and your heart?
Oh, the first I think of is always the families who lost so much. It's a sad day for everyone, but particularly those who lost their husbands or wives or parents or children on that horrible day. So my first thought is always of them and how much they are suffering. And now 20 years later, my thought is also of how we have rebuilt Ground Zero and how it has risen from the ashes. And I'm very proud of that.
You were one of the architects of the rebuilding of the 11 acres at Ground Zero. Now, looking at the site 20 years later, what are your thoughts?
I'm very proud, Javier, of how we rebuilt Ground Zero. We had to do a number of things. We had to first remember those heroes who died, and the memorial with the voids where the towers actually stood and the names around those voids, I think, is very moving and appropriate so that people don't forget those who died. The second is we wanted for future generations, people not born on September 11th, to understand the magnitude of those attacks and that our freedom is something we can't take for granted. And there are those who are always going to resent the fact that we have freedom of speech, freedom of religion, freedom of assembly, and we were attacked because of our belief in those freedoms. And finally, we had to rebuild the commerce of Lower Manhattan. And you look and you see the towers culminating in the tallest tower in the Western Hemisphere, the Freedom Tower. And it makes me very proud that the vision we had to bring back not just Lower Manhattan, but to bring back New York's confidence in our future, we were able to accomplish.
Governor, at the time, there was a lot of discussion if whether the site should be intact as a sacred ground or hallowed ground. Do you think you were able to find the good balance between both?
Javier, that was the key, is finding the balance. There were those who thought, let's move on, let's just rebuild for commerce and let the books tell the story of the attacks. But I felt that the site had to tell the story of those attacks and honor those who died that day. And there were those who said we had to forget about bringing back commerce and rebuilding the economy of Lower Manhattan. But we couldn't do that as well because we had to make sure that New York continued to thrive as a commercial center, as a global center of finance and commerce. And we were able to achieve that balance. It wasn't easy, but it was important, and we got it done.
As the 20th anniversary of September 11th approaches, we are witnessing the withdrawal of military troops from Afghanistan. Do you have any thoughts about that, the timing, anything you can say?
I think the withdrawal was wrong at this time. I think it was done in a hurried and incompetent manner. And of course, we lost too many brave soldiers because of the incompetence and hurried nature. And I also fear that it was rushed so that it could be announced that on September 11th, 20 years later, the endless war was over. Well, it's not over. Those who attacked us before, ISIS, Al Qaeda, the Taliban, those who detest our freedoms, are more confident than ever and are more committed than ever to attacking us again. So I fear that this hurried withdrawal, done in such a bad manner, just makes us far more vulnerable to attack than we were 2 or 3 months ago.
In the context of September 11th, what is your message for the future of to New Yorkers and for Americans?
You know, we had many very tough days and weeks and months after September 11th, but we came back. And right now we're having a tough time in New York, but we'll come back because this is New York. And we always have our ups and downs, but ultimately we always have our ability to pull together, come together, and build a better future. And I'm confident that we're going to see that now, where New York, yes, we're having tough times again, but we'll get through it, we'll come back, and we'll be stronger than ever, as we always have been.
For the sake of transparency, I always like to disclose that I worked as one of your press officers during the administrations. So I saw some of the decisions as they were being made. So I'm very familiar with the process. Governor, I always have been wanting to ask you, even from that time, what were the most difficult aspects of working on the September 11th situation?
Well, there were a number, obviously. First, the families, because we had to reach out to them and make sure they got the emotional support they needed in their time of tremendous loss. The second was we didn't know what might happen next. Would there be more attacks? You know, were these the only attacks, or would there be more? And we had to do everything in our power to try to protect us from additional terrorist attacks. And then finally, people didn't want to come to New York. New York was a dangerous place. It had been attacked, and we depend on people from around the country and around the world coming to New York, and they weren't. So we had to convince the world that New York was safe, that it was a place you could come back to and you could enjoy the tremendous life that is so characteristic of New York. And then we had to rebuild for the long term at ground zero. And it was very controversial to achieve that balance between memory and building for the future. And I think we were able to do all that because New Yorkers came together in such a tremendous and strong way. And that's what we need to do now, Javier, come together again and understand that the future is not just for one group or another. We're all in this together. Our future is a common future. And when we work together, we can accomplish anything.
Thank you for joining us today, George Elmer Pataki, 53rd governor of the state of New York, in office from 1995 to 2006.
Thank you, Javier. Nice being with you.
Okay, we're back. I'm your host, David Lesch. We have with us today Claudia Henriquez, the Director of Litigation at the Office of Labor Policy and Standards. Claudia, thanks for being here today.
Thank you for having me.
Important topic. Let's talk employees and many who are unfortunately taken advantage of pre-COVID and now through the whole pandemic. Talk to us a little bit about how employers try to take advantage with respect to hours and with respect to time in terms of the employees of our city, if you could.
Sure. So I'm going to talk specifically about a law that our office enforces called the Fair Workweek Law. It applies to fast food and retail workers in New York City. It went into effect in November of 2017. So pre-COVID, it was already an issue. These two industries were flagged for, being particularly egregious in violations. In the retail sector, retail employers are required to provide schedules to workers at least 72 hours in advance. And the Fair Workweek Law prohibits employers from changing employee schedules, adding shifts, canceling them, within those 72 hours. It prohibits a practice in that industry called on-call scheduling. And in fast food, there are protections for workers as well. The fast food industry requires, or rather Fair Workweek as it applies to the fast food industry, requires employers to, first of all, give workers what's called sort of their general schedule. It used to be called the good faith estimate. It gives you generally what your hours are going to be. So maybe that's Monday, Wednesday, Friday, 9 to 5, just so you are able to plan your life. And that's the whole point about these laws. They were enacted to allow workers to plan their lives, to plan for childcare, maybe go to school, get a second job. So that, you know, for fast food workers, also it's required that the employer give them their actual schedules 2 weeks in advance.
And by the way, this is common. I see here a Pizza Hut in the Bronx and a McDonald's in Brooklyn had to pay $221,000 in restitution to 135 workers for violating the Fair Workweek Law. So you guys are right in front of it. I mean, you're there. This is happening every day in our city.
That's correct. That's correct. And so in those cases, you know, just to go back a bit and wrap up sort of what the law requires for fast food workers, you know, I mentioned the schedule. There's a premium pay that the employer is required to pay if they change the worker's schedule within those 2 weeks. They have to get their written consent. There's regulations around what's called clopenings, which is where the worker closes the store the night before and the same worker opens the following morning. So that's prohibited unless the employer gets the worker's written consent and pays them $100 premium. So in those cases that you mentioned, essentially all of those practices were taking place, all of those prohibited practices. And in the Pizza Hut case, it was a particularly egregious case because it was a worker who complained. First of all, she had taken sick time, which is another law that our office enforces in 2018. She was never paid for it. Then in early 2019, she noticed she also wasn't being paid for her premiums, complained, was brought into a meeting with her supervisors and managers, was reprimanded, and after that, her hours were cut. And, not too long after that, she was fired, which that was her complete loss of income, ended up with her being homeless. So that led her to file a complaint with our office. And this is actually not the first case that our office has handled where an employee was fired and ended up homeless, I'm sad to say.
You know, my understanding of the law, which, I now realize is not necessarily correct with what's been happening here, is that I was always under the impression that if employees are basically employees without a contract, without a Derek Jeter or Yankee Stadium contract with the Yankees, if you don't have a contract, you're an employee at will. And if you as an employer have a bad dream about that employee, you could wake up in the next morning and just say, look, it's been nice knowing you. I'm firing you without cause. I just have a bad dream about you. But you can't do that anymore. Am I correct?
So always under both our paid sick leave law as well as Fair Workweek, and actually any of the laws the department enforces, there have always been very strong anti-retaliation provisions. So you're correct. The Fair Workweek law was recently amended to include this prohibition on firing workers unless there is just cause or a legitimate economic reason. But even before then, workers were protected for asserting their rights, as this complainant did, asking about her premium pay. That was protected activity, and an employer who fired a worker for asserting their rights would be liable. There's statutory damages, there's back pay. In her case, it ended up adding up to $27,000.
So I know a lot of laws, went into effect at least before COVID even hit. So this was obviously prevalent throughout the city. But since the pandemic, has this seemed to have gotten worse, better, or stayed the same?
It's hard to say. There are some unique staffing challenges that we saw, particularly in the early, the spring wave where, maybe people weren't showing up to work, or the employer had to suddenly close because some employees tested positive. And so we were getting a lot of inquiries on sort of how that intersects with Fair Workweek. So there are certainly challenges that are unique to COVID, but sadly, as I mentioned earlier, this law went into effect in 2017. So in this industry, this has always been an issue. And, one of the things that is a little better is that now more employers know about this law. And so we are seeing, while there are widespread violations, we are seeing more employers sort of trying to come into compliance.
But I'm sure you see some employers who are trying to skirt the law by maybe getting agreements with the with the employees in terms of, okay, you can work triple shifts, or I'm not going to give you the notice that's requisite for you to know that I'm putting you on immediately. Is that happening?
So the law requires written consent. So you can add an employee, for example, in the fast food industry, you can add shifts to their schedule as long as they agree in writing and that you pay them the premium. So there is an opportunity for employees to acquire more work should they want it. But what we don't like to see and have seen is where, for example, the employer forges the employee's signature or adds them to the schedule without their consent or makes them feel like they can't say no, or they're sort of coerced to take the shift. So there are ways that employers, even doing sort of on paper things that look legal, when you dig a little further and talk to workers, that's not actually the case.
Claudia, we don't have too much time, but what tips would you give to someone who's watching right now who believes they're being taken advantage of by their employer? What would you tell them to do?
So the first thing I would say is to document everything. So, document your hours. Many employers don't keep very good records, even though it's their legal responsibility to do so. Document your hours, document when you're paid, how much you're paid. If you have any conversations with your managers, keep notes of that, because if this does go to an investigation or litigation, then that will be your contemporaneous evidence that you kept. You can use that in court. But also call our office 311. You can say worker, that will direct you specifically to the Office of Labor Policy and Standards. We do evaluate every complaint that we receive. We're statutorily required to do so. So, call our office, but in the meantime, keep notes and keep all your records so that when you do have an interview with our investigator, you have all your evidence there ready to go. That definitely helps the case.
Great advice. Claudia Henriquez, I want to thank you very much for being on. We love to work with your office and having your different guests come on. And please come back maybe in a couple of weeks and give us an update.
Thank you very much.
It's our pleasure. All right, stay with us. Today's verdict, so much more right after this. Okay, welcome back to today's verdict. I'm your host and trial attorney, David Lesch. Rebecca Serbin is here to discuss disability rights, certainly a very important topic. A lot of children, unfortunately, are left behind when it's not even COVID. So Rebecca, thanks for being here today.
Thank you so much for having me.
It's an important discussion. It really is. And anyone who doesn't think that the disabled shouldn't be getting more is heartless. But that being said, let's talk a little bit about your organization. You're a disability rights advocate, and just tell us a little bit about what you do, if you could.
Certainly. So I am a staff attorney at Disability Rights Advocates. We are a nonprofit that was founded in Berkeley, California, which is sort of the home of the disability rights movement in the early 90s, shortly after the passage of the Americans with Disabilities Act. And we've had a New York office for a little bit under a decade. I'm out here in our New York office, and we do impact disability rights litigation, largely under the ADA, but under some other federal and local civil rights statutes for people with disabilities. And we do work in sort of all areas that affect disability rights, from education, like this case, to transportation, housing, employment, sort of all across the board.
Let's take you back a year and a half ago, pre-COVID. How has your work changed based on what you used to do, in terms of kids who were already in school every day, to now where at best you had a hybrid model? How has your work changed, really?
Certainly. So this case was filed before COVID and has to do with an issue that existed long before COVID and that continues to exist, but that is not COVID specific. We've certainly heard from lots of families who've been having a whole range of COVID specific issues. Those, sort of fall outside this case. And there are other organizations in town that are doing wonderful work sort of specifically on the issue of all of the kinds of missed educational services and other services during COVID times, as certainly, as you know, lots of students struggled during remote learning, and it was particularly challenging for many students with disabilities, many of whom missed really important services and other aspects of their education.
Let's talk about the case. It was successful. Tell the viewers about where it even started.
Absolutely. So this case was filed in 2017, and we brought the case on behalf of 2 Bronx students with disabilities and the Bronx Independent Living Services, which is a wonderful community-based organization in the Bronx. And we did the investigation for this case along with the Public Advocate's Office back during Attorney General James' tenure as public advocate. And although they were not involved in the litigation part of things, and we were hearing from families about this issue relating to related service authorization vouchers. So if I can provide just sort of some very brief background, under the IDEA, which is the Individuals with Disabilities Education Act, many students with disabilities have what are called IEPs, or individualized education plans, under which they get certain specialized education services, and often also what are called related services in order to have access to public education. And these related services include things like speech therapy, occupational therapy, and counseling. And these are really key services that many students with disabilities need in order to really to have their educational rights realized. And so typically students receive these services in schools. But in New York, when the Department of Education is not able to identify a provider to provide those services in schools, whether or not it's a New York City DOE employee or someone they contract with, they often issue families these vouchers called related service authorization vouchers. And they say to the family, you find a provider, here's a list of providers, and we will then pay for the services. This certainly works for some families, but in many cases, including in sort of the last year where there was public data on this that we know of in the Bronx, more than half of these vouchers ended up going unused. And so something was going wrong in the system students were missing services and were not being able to turn these vouchers into services.
Well, let me ask you a question. Was that because, families didn't want to leave the house to go get a provider because they were afraid of getting COVID? Or is that just because maybe these families don't know how to navigate, just the websites to get to the person, or maybe both? What's the reason for it?
So this was all of this was, talking about sort of the way things were in 2017. So before COVID was on the table, I think our understanding is from talking to families, it's sort of different factors. Some of the time it was that not enough information was given to the family for them to know sort of how to proceed. Sometimes families would call a tremendous number of the numbers on the list of providers that the DOE provided and would find that many folks were not available. They weren't accepting the vouchers anymore. They weren't willing to come to the Bronx. So sort of a variety of issues, and sort of all stemming from the fact that the whole system is when the DOE can't meet this burden itself, they're placing that burden on families.
And it's hard enough just having a disabled child, to now all of a sudden you have to figure out the process of getting them all the things that they need to do. And some of these parents are just not equipped mentally to be able to get ahead of it and do this. So the schools could do it for you, and they're just outsourcing it. And they're basically saying, okay, it's on you now. So where did this lead?
Certainly. So we filed the case in 2017 and pretty quickly went into settlement negotiations. And we negotiated with the DOE. We had a joint expert who is an occupational therapy professor at NYU who spoke to stakeholders and reviewed key information and provided recommendations on sort of how to go about solving this problem. And we ended up with a settlement that was then a bit delayed for COVID reasons, but that we finally finalized at the beginning of this year and that has now received final approval from the court. And this was in the Southern District of New York. And under this, the sort of two key areas of the settlement. The first is various policies, practices, and procedures to increase the DOE's capacity to provide these services in schools and avoid having to provide the vouchers in the first place. And then in the event that they still do need to provide a voucher, sort of in the second area, increasing and improving the information and support that families get to actually use the vouchers, and also streamlining the process for families to get makeup services for their student if the student misses services between when the service was supposed to start and when they're actually able to use the voucher.
Can I ask you a question? Who monitors them now? Who makes sure that they follow the procedures that they need to follow as based on the settlement? Who's the watchdog for them?
Certainly. So we are. We at Disability Rights Advocates will be monitoring the settlements. The DOE will be providing us with information to demonstrate both that they've done sort of some of the certain specific changes required under the settlement, but also providing data as to how this is going, how this is, what the outcomes are in terms of these vouchers and the vouchers being used over the term of the settlement, which is the next 3 school years.
By the way, does there seem to be a trend now with a little more sympathy to those who are disabled, specifically children, in terms of services? You know, sometimes these things ebb and flows, but does there seem to be a general empathy among courts, among legislators in terms of this area you're working in?
I mean, I don't know. It's a tough question. I do think it sometimes feels like there's sort of a general positive trend toward more folks across the board recognizing that disability rights are a key component of civil rights. And so it certainly can feel like there's forward momentum there, but there's also still a tremendous amount of progress.
In my field, jurors aren't so giving with automobile accident cases, but with sexual harassment cases, they are. It depends on, where their general feelings are. And I guess that's really why I was asking. Final thoughts. We don't have too much time with you. Somebody wants to reach out. They may have a disabled child. They have an issue that they want you to get in front of and tackle. Where do they find you?
Absolutely. So our organization is called Disability Rights Advocates. Our website is dralegal.org. If anyone has a question about this settlement or in general, our contact information is on our website. And we also have a particular email address about this settlement, rsa@dralegal.org. And then and we can also direct those folks to the email address or phone number for contacting the DOE if they think their student might be eligible for makeup services under the settlement.
Perfect. Rebecca Serbin, I want to thank you very much for being here. Come on back, say hello, and stay safe.
Thank you so much.
All right. Today's verdict, so much more coming back at you right after this. Well, that's all we have for today. I'd like to thank our guests for joining us, and of course, you, the viewers, for watching. If there is an issue that you would like to see on a future edition of Today's Verdict, feel free to email me at davidlesch@bronxnet.org. Until the next time, know your issues, reach a verdict. See you in 2 weeks.